British Columbia Trade and Invest representative here in the Pacific Northwest. Our organization has two main goals: helping BC companies expand in the US, gain access to new markets, and raise funds in some cases, and also work with US-based companies that are expanding into British Columbia. We have a team of people across the US, in the Bay Area, in LA, in Austin, in the Pacific Northwest, where I am, in the East Coast as well. And we're here to help with anything you need. So something very practical, a very practical tool that I would like to share with you all today. It's a recently launched tool by Innovate BC, which is an organization based in British Columbia that basically brings together all the innovation ecosystem from the province. And they recently launched this tool called Capital Compass, right? And it's basically a one-stop shop where you can find information about the information about the BC ecosystem, companies, deals that are happening, like funding rounds. It's powered by Deal Room. So I really encourage you all to check it out. I'm sharing the screen here really quick, just so you see the depth of information that this tool has. Yeah, I really encourage you to go and play with it a little bit and see what you can find, because it's up to date. It really includes everything that's happening in the province, and I believe that you will find it of value. The last thing I say is that if you are looking to go up to BC, to Vancouver, to check out what's happening in person, there's a good opportunity coming up in April. There's a conference called Innovate West that's gonna be taking place in the Vancouver Convention Center, and it's gonna be a great opportunity to connect with the BC ecosystem and to learn firsthand what's happening and who are the players that are active these days in the province. So I will share both the links for Capital Compass and Innovate West in the chat room, so you can all have it. And with that, I'm gonna pass it to Fiona and Felix, who are gonna be giving us a presentation on the general topics of doing business in BC and in Canada. So thank you all.
Perfect. Thank you so much, Nico. So Felix, do you have the slides up?
Yeah, give me one moment. I'm just trying to pull it up
here.
Yeah,
take your time. So we are just thrilled to be speaking with you. It's such a pleasure. We'd be thrilled for you to reach out following this presentation. You know, we're just going to be speaking at quite a high level today, and we welcome no charge, non-billable calls to discuss with you further what it looks like to expand into Canada and BC. So by all means, reach out. Our emails are set out on the last page, but just for your convenience, my email is fbrown@airdburles.com. And again, because, you know, we were connected to you through Nico, really as many no charge calls as you need before you feel comfortable moving forward with Canada and BC, it would be our pleasure. So yeah, we can just jump right into it. My name is Fiona Brown. I'm a partner at Aird & Burles. Aird & Burles is a full-service Canadian law firm. We're roughly 300 lawyers, which makes us one of the largest law firms in Canada. We're coast to coast. And my particular area of expertise is market expansion. So every day, all day long, I'm helping international companies set up in Canada, many from the US. And as you can see, we have many industries, and we have expertise in many industries, and we'll really be able to help you with absolutely everything you may need, while Felix and I will get you set up in Canada and in BC. As you grow, and many of our clients do, we'll be able to build a team within the firm to help you with anything else you may need.
Sorry, can everyone hear me? I seem to be losing connection here. Yeah, okay, no problem.
Great.
Sorry, I'm just moving. Thanks, Fiona. Yeah, so setting up a Canadian entity in Canada, there are really just two main decisions you have to make here. So unlike in the US, where we have a federal corporate statute, or you can incorporate in any of the provinces in Canada. For an international company expanding in Canada, the federal option is typically not the path that's chosen, and the main reason for that is because there's a requirement to have a Canadian resident director, which at the beginning stages of a Canadian expansion is not likely that you'll have someone who you want to appoint into such an important role. Luckily, there are many provinces, including BC, where many of our clients are setting up their Canadian entity in, that don't have that Canadian resident director requirement. And from a corporate law perspective, the federal statute and the provincial statutes across Canada, with the exception of Quebec, are substantially the same outside of the Canadian resident director requirement. And similar to the States, just because you incorporate in a particular jurisdiction, that doesn't prevent you from doing business in any other provinces across Canada. So in the States, a lot of companies are incorporating in Delaware, but are doing carrying on business in New York, California, what have you. Similar to what we have up here is called an extra-provincial registration, which would give, if you were to set up in BC, your British Columbia corporation the right to carry on business across Canada. And it's a simple filing that's, I imagine, quite similar to what you have in the States. It's a simple administrative filing that would give your company the right to carry on business there. The second major decision that you have to make is the type of entity you want to use. So in the States, I know you have the S Corp, C Corps, LLCs. In Canada, we really have just two options, and I'd say 99% of the companies that we're working with are using one, and that's the standard vanilla limited liability corporation. It's akin to S Corp in the US. But for US companies expanding to Canada, there's something called an unlimited liability corporation, which is it's a unique corporate structure that's available in a couple of provinces, including BC, which is of interest for US investors because of the way it's viewed under US tax law. So under certain circumstances, an ULC can be viewed as a disregarded entity. And what that means is that if the Canadian entity will have losses moving forward, if it would be used as a cost center, those losses under a ULC would not be trapped at the Canadian level, and those losses can actually be brought back to offset profits at your US entity level. But again, most of the companies that we're dealing with, I'd say even from the US, have just proceeded with the standard vanilla limited liability corporation. But it's just something that we want to put on your radar, just so you're aware of the different options that you have up here in Canada. So the typical process of how we set up your Canadian entity is that we'll send to you a pre-incorporation checklist, which sets out 5 or 6 different questions that we need answered in order to set up the company, 2 of which we've already talked about: the jurisdiction and the type of entity. And the remainder questions are quite similar to what you have in the States. So who will be acting as the directors, officers, and shareholders of your company? And so everything for the incorporation can be done through electronic signatures, through DocuSign, and it can be done so very quickly within 24 hours. And unlike certain states in the U.S., we have no minimum investment requirement. I believe in California, there's a franchise tax, which puts a little bit of an extra level of consideration that we don't have up here. A frequent question that we get from international companies looking to set up in Canada is, what are the corporate maintenance requirements after your company has been set up? And the answer is, it's very simple, and it's that for majority of the jurisdictions across Canada is that you'll just have to file what we call an annual report or an annual return with the applicable corporate registry, which essentially just updates the public records of any changes in address or directors and officers. And your corporation will also have to hold annual director and shareholders meetings. But for privately held companies, those are typically done away with through written resolution. So you don't actually have to physically have a physical meeting. Similar to what we do before we set up your corporation, after your company has been set up, we'll also send to you a post-incorporation checklist, which is a dashboard of different items that we want to put on your radar once your company has been set up, understanding that this is a foreign jurisdiction that you're expanding into. So I spoke about the extra-provincial registration earlier on, for example, where if you set up in BC, you'll have to extra-provincially register in other provinces you want to carry on business in. Another one is what we call an Investment Canada Act filing, which is essentially a disclosure exercise with the federal government whenever a non-Canadian makes an investment in Canada. And this requirement is triggered if you're setting up a new entity when you hire employees and you own or lease real estate. So this is something that may not be triggered until down the road as your Canadian expansion grows, especially since many companies are going through the work from home type model. So I'm headed over to Fiona to speak about some employment considerations in Canada.
Great, thanks, Felix. So really, just as on the corporate side, where we'll be here to hold your hand every step of the way, we'll do the same on the employment side. In Canada, industries are subject to different employment laws actually based on their industry. The overwhelming majority of our clients and industries are subject to provincial employment legislation, meaning the employment laws will vary based on where the employees are performing work. The good news is the laws are substantially similar, and BC is quite an employer-friendly jurisdiction, which is a great thing. And Felix, if you don't mind, just going to the next slide. Thank you. The first piece of advice to our clients expanding into BC, once the entity is established, is that you really want to have an employment agreement in place. So we understand that in the US, it's at will unless an employment document provides otherwise. In BC, it's really the opposite. So in BC, the default is quite employee friendly and comes from judge-made law. The good news is, by way of an employment agreement, you can waive that judge-made law and instead agree to a different set of entitlements. So many of our American clients will hear horror stories about what happens in Canada upon a termination and that it can be quite expensive to terminate. That should not be the case. That really should not be the case. It's just because they didn't have an employment agreement in place. So for our clients, we really insist they have an employment agreement in place that provides adequate protection. And in that event, terminations can be quite simple, very, very cost effective. Cost will not be a concern if you have the right employment agreement in place. And Felix, next slide, thanks. Yeah, and so here's some additional resources that we encourage you to, check out. And please reach out, because we would just be thrilled to carry on this conversation. And we suspect you will be pleasantly surprised at how simple it can be to do business in BC.
Perfect. Perfect. Felix, is there anything else that you would like to add?
No, that's it from my end, unless we want to open the floor up to any questions that the group might have.
Okay, yeah, but perhaps before that, I want to do two things. First, acknowledge my colleague and friend Rob Fiddick from the Canadian Consulate in Seattle, who has joined us as well, and it's an amazing resource for any of you thinking of expanding into Canada, be that BC or other provinces in the country. So thank you, Rob, for being here today. And then I want to especially thank Frank because last minute he volunteered to be in this webinar. And the reason why we really wanted him here is because before the webinar, we started getting some questions that were very tax intensive, and we needed someone with that expertise, and well, we found Frank thanks to Fiona and Felix, and he's an amazing expert to have here today. So Frank, perhaps I pass it to you, and if you don't mind introducing yourself really quick and giving us a 5-minute brief of the Canadian taxation system, and then we open the floor for questions, so we make this as practical as possible for everyone here.
All right, thanks, Nicholas. Hi, everyone. So as a formal introduction, my name is Frank Cassiero. I lead our Global Employer Services Group for RSM Canada. And what we specialize in is any sort of cross-border employment arrangement. So if you're looking to send employees to work in another country or remotely hire them to work from another country, any sort of cross-border arrangement creates a whole list of payroll and tax issues for the company as well as for the employee. So we get involved to help navigate all through that and ensure everyone is compliant across the board. So although this webinar originally looked like it was supposed to be more of from a legal perspective, it made sense to include a little component on tax just because, in addition to legal, knowing what you need to do from a legal standpoint, you're going to be exposed to tax as soon as you cross the border into Canada and looking to expand operations here, whether that's setting up a branch corporation within Canada, or sorry, a subsidiary in Canada or a sister company, or just having a branch and you're operating foreign. So just as a quick little 5-minute summary on the tax implication. So whenever you're looking at coming to Canada, you're going to be exposed to the Canadian tax system, right? And our tax system is comprised of corporate tax, indirect tax or sales tax, and then as well as payroll and personal income tax in regards to the company as well as the employee. Now, if you're looking at setting up a Canadian company incorporated in Canada, then obviously all those items would apply automatically, just because having a Canadian entity, also assuming that you're going to be hiring Canadian-based employees. So, all those things would apply from the start. In regards to how they apply and what's required, it would be definitely based on, how you're setting up the entity, where you're setting it up, what you're doing in Canada, and so forth. And then, that requires registrations with the Canada Revenue Agency to get the tax numbers for each level of taxation and just being compliant across the board. Where it could get a little complicated is if you're looking to expand into Canada, but not setting up an entity in Canada, you're just maybe want to test the waters first and send a few people into Canada just to see, okay, is expanding to Canada make sense? Should we look into it any further? In that scenario where you're not setting up an entity, there's still exposure to tax in Canada for all three levels again, corporate, sales tax, as well as payroll, individual tax. But when you're operating as a foreign entity, especially if you're sending foreign people into Canada, there could be some exemptions under a tax treaty Canada may have with the foreign entity, or sorry, the foreign country that's sending people in or where the entity is originally from. And if those tax treaties exist, there could be some exemptions to alleviate or possibly just reduce some of the exposure in Canada from a tax perspective, right? Best case scenario, you don't have to do anything. Worst case scenario, you got to pay tax everywhere. Like if you set up a Canadian company and then, the middle of that is possibly reporting, maybe being tax exempt and so forth, right? And as I said, every level kind of has their own rules as to come to whether you're exposed to it, whether you're required to file anything, and then whether you're exempt under the treaty. So, in addition to making sure you're compliant from a legal standpoint, immigration standpoint, you definitely want to get the tax side covered, hopefully before you come into Canada, just to make sure there's, no surprises after the fact, right? So just a little FYI on, coming into Canada, you're definitely have taxes that you need to be aware of and compliant with. So, all right, thank you.
Great. Frank, I have a question here, like that I don't know if you got a chance to see in the chat room. Like this is very helpful to understand how to start a business in Canada, right? But what should besides what you just said about the knowing that there are taxes obviously specific to the Canadian context, that what should US companies or investors know about investing in a company that someone else already set up in Canada, right? Like here, the standard vehicle for investment is a Delaware C Corp. Like, what should investors know when they say, let's say, they are investing in a VC-based company?
When U.S. individuals in particular, whether they're individuals like themselves or they're operating through an entity, whether it's a C Corp, S Corp, LLC, and so forth, one thing to be aware of is that in the US, we have those different type of entities that I mentioned, but in Canada, they're all viewed the same way. And what I mean from that is, from a tax perspective, where an LLC or an S corp is a flow through for U.S. purposes, where the ultimate shareholder is really the one that's going to be exposed to tax at a U.S. Level. In Canada, the flow through mechanism is not recognized. So if you're operating as an LLC or an S corp, Canada looks at that entity as separate from the owner. And what that means is that the actual entity is going to be the one that's exposed to corporate tax in Canada. Now, the issue there is the tax treaty that I mentioned before that Canada has with the US. It does provide relief from double taxation. So at the end of the day, if you're subject to tax in both countries, the treaty comes in and says, hey, we'll give you a credit in one country for tax paid in the other, right? Now, where this may not apply is if you're operating through an entity where the US treats it as one way and Canada treats it as something different, right? So an LLC, for instance, Canada sees it as a corporation separate from its owner, where in the US it could be considered a flow through or a partnership where the income flows up to the member or the shareholder. In that scenario, when you've got different treatment, that's where double tax may come into play. And that's where the treaty, the foreign tax credit mechanism under the treaty may not be applicable, right? So there's definitely planning and there's definitely consulting that should be done before any investment into Canada, especially if you're operating through a US entity, to avoid any sort of double tax exposure, right? You definitely want to make sure that, you don't want to pay any more tax than you have to. So you could look at setting up certain structures and maybe having certain entities in the middle of the ownership to kind of alleviate some of this burden. But it definitely does require a full review on the US investment, how they're set up, or the investor, sorry, how they're set up in terms of what entity they're operating through, and then how they're going to be investing into Canada in a Canadian entity, just to avoid the headaches, as I mentioned. And in addition to all that, on the US side, the IRS, as well as the Treasury Department, require a significant amount of reporting for any US-based person that has foreign investments, foreign ownership of foreign companies, foreign involvement in any trusts, partnerships, and so forth. So at the very least, even if we iron out all the consulting side of things, your compliance costs in Canada will go up, in the US will go up strictly just for the foreign disclosure requirements that need to be done in the US to report any investment in a non-US foreign entity or investment. So.
Great, thank you for that answer, Frank. And this one, I believe it's a good question for Felix. And it's posed by Anthony Barron. Thank you, Anthony. So the question is, what are the advantages or disadvantages of setting up an entity in BC rather than operating as a foreign LLC, like let's say like a US Washington LLC entity?
So this is sort of a hybrid answer. So I think, Frank, this might be something that we can touch on about permanent establishment on the tax side for sure. But on the legal side, the main benefit is limiting your liabilities in Canada. So if you set up a Canadian subsidiary, presumably to have Canadian operations, Canadian customers, any liability that your Canadian operations might contract into is limited to your subsidiary that would most likely have less assets than bringing in your parent entity from the States into the Canadian legal realm. So that's the main advantage from the legal side. And on the tax side, maybe I'll hint, I don't want to put you on the spot, Frank, but on the permanent establishment, you would be creating, potentially dragging your parent entity into the Canadian tax regime by virtue of doing business in Canada, depending on what your operations look like. And that's something a lot of companies try to avoid, as the tax filings just get a bit more complicated if you have your U.S. entity carry on business directly in Canada.
And just to follow up on Felix said, yeah, for tax purposes, a foreign corporation is exposed to Canadian corporate tax if they have a permanent establishment, as Felix said. And a permanent establishment could be comprised of actually having a physical presence in Canada, meaning you have an office set up here, or it could be as trivial as based on having some employees, foreign employees of Canada, performing duties and the amount of time that they're here. And there could be mechanisms under the treaty to help alleviate that permanent establishment exposure. But as Felix indicated, it's definitely something that needs to be looked at before the activity happens in Canada, just to ensure that, if we can avoid it from the start, we can't, then we put those pieces in place to achieve it. So.
Great. And I encourage if everyone has questions to like just raise your hand on the Zoom and pose those questions orally if you want to make it more dynamic. Yeah, if anyone has other questions, just raise your hand and we'll give you the opportunity to speak. There's a couple of other questions in the chat room. I'm gonna go with one posed by Jonathan that I believe it's a question for actually the two of you, Felix and Frank. You know, does the Investment Canada Act impacts investments made by U.S. entities in Canadian companies that are not majority or controlling interest, in which they don't have a majority or controlling interest? Felix, Frank, who wants?
Generally, no. So it does. There's nuances in the Investment Canada Act, but generally you do need to acquire a controlling interest. Now, sometimes we understand that controlling sometimes mean less than 50%, either through, for example, shareholders agreement, which give you more control than your shareholding suggests. But generally, you need majority control of voting interest in order for it to trigger that ICA requirement.
Frank, would you like to add anything to that, or?
From a tax perspective, the act doesn't really impact what your tax exposure is. If you're looking at gaining a controlling or a majority interest, outside of just simple issues under tax, meaning, if there's a change of control, you might have to file a different tax return, report the change of control and so forth. The one thing I will mention in Canada is we have what's called a Canadian Controlled Private Corporation, or a CCPC. Meaning that if it's controlled by Canadian resident shareholders, you get beneficial tax rates and some beneficial credits that are not allowed to be claimed by a non-CCPC or a foreign controlled corporation. So if you're a U.S. investor coming in to acquire, say, a Canadian entity, and you wind up acquiring a majority share, where now it's not really considered a CCPC anymore, you might lose out on that beneficial tax rate and those credits. So that's one thing to be aware of. And that could be kind of circumvented if, you get a certain organizational structure set up where you still have Canadian controlled designation, which meaning, involving some ownership to be by Canadian residents. So just to throw that in there.
No, that's great that you mentioned that, Frank. So I have a question, perhaps more from like a day-to-day perspective, right? What are you seeing? Like, I mean, you work with a lot of international clients, right? Companies that are expanding into Canada. Like, what are their main concerns when they arrive? Because I know, at least in my role, I get people concerned about the employment laws in Canada, right? That it's not the same as in the US. Some other people obviously are concerned about the tax issues that might arise with an international investment. What are the most common questions that you two get when working with foreign clients?
Well, it's funny because I'm the tax person, so obviously you would figure most of the questions, I guess, should be tax related, but I get a lot of questions that actually fall into Felix and like Fiona's side of it, and that's why we're always quick to pull them in to handle the legal side. So they ask, okay, what's our tax exposure in Canada? If we're sending people in or if we hire them, Canadian residents or local employees. They ask, oh, I have a pension plan in the US for my US employees. Can I use that for the Canadian employees? They also ask, I have a medical dental plan in the US for my US employees. Can I use that for the Canadian employees? Employment law, we have an agreement that's reviewed by a US lawyer. Is that applicable in Canada? And I usually say no to everything, because anything that's very US specific or foreign specific, whether it's a plan, a legal document, anything of that nature, has to be looked at from a Canadian perspective, right? Or a Canadian legal eye and tax eye when you have people in Canada. So, that foreign pension plan may not work in Canada, right? That foreign medical dental plan may not work in Canada. Definitely employment law is one thing I always say, reach out to Aaron and Burles to get that looked at, because, especially employment law in the US, doesn't necessarily work well for Canadians. And then immigration, right? You know, at the end of the day, you're exposed to tax whether you're in Canada legally or not. So you definitely want to make sure that there's no reason why, you know, people can't cross a border to get the job done if you've got an engagement that you need serviced, right? So those are the things I see.
Okay. Felix, would you like to add something there, or Fiona, or?
Yeah, it's a really good question. I would say we are kept quite busy by our clients just Canadianizing / localizing various agreements. So whether it's an assignment of IP agreement or an agreement with your clients, there just are different concepts that apply. And unfortunately, we do see a lot of clients try to get away with their US agreements and just, you know, have them work in Canada. Unfortunately, not all of the concepts translate over, or, you know, an agreement may say something, but that doesn't mean it's going to be enforced if the right language isn't there. So we have seen some clients sort of make that mistake, and we don't want any of you to be in that position. So sometimes it's a bit of penny wise, pound foolish. And oftentimes it can be really cost effective to have agreements drafted, but it can just be a lot more expensive to fix the problem.
Great, and we have a really good question by Rick Tom Horde. I'm sorry if I'm mispronouncing the surname, but the question is like, as US-based angel investors, we often hear Canadian companies only do common shares for tax reason, not preferred shares, which investors obviously prefer for rights, right? So the question from Rick is, does this have to do with the CCPC regulations that you mentioned? Can you elaborate a little bit on that, Frank and Felix?
I don't know who wants to go first with this question.
I mean, from a legal, like a corporate law perspective, there's really no difference. I see it used both ways, but perhaps there is a tax consideration that that Frank can speak about. But from legal perspective, I see investors invest in both common and preferred. Like the name itself, common, preferred, from a strictly legal perspective, doesn't actually mean anything. It's really what the share provisions itself say. So I don't know if you have anything to add on the tax side, Frank.
Yeah, I mean, I've seen companies from a tax perspective have both type of shares being offered. I mean, at the end of the day, it really comes down to what type of investor they want to invest in and the offerings they give them. What I will say is, lots of times when I see preferred shares, it's usually in a company reorganization where they want to lock in the value of the company at a particular time, and they lock it to a preferred share that is only offered to, say, the owner or various, you know, or maybe the owner's family members for like estate tax purposes, or for you know, estate planning and so forth. I mean, in Canada, usually that's when we see preferred shares is in that scenario. But I have seen other companies where, you know, they may want a particular type of investor, so they may give it a preferred share to have some extra attributes associated with it compared to a common share that might be open to anybody. So.
Great. That's a great answer. And we have a couple of more questions here. Some get really specific, which might be good to bring things down to earth. And I'm going to go with one of those. Perhaps this one is more suitable for your practice, Frank. So the question is, if a US investor invests 25K and 5 years later gets a 125K payout on a sale, they will pay a 100K capital gains tax to Canada and still owe US capital gains, but a credit for what they pay to Canada. Is that how it works with the double taxation agreements?
Yeah, so ignoring tax treaties and anything else, usually, now this could be a little bit more complicated, and I know I don't want to go past 4, obviously. In the grand scheme of things, if you're just a US person and a non-resident of Canada, let's just say, ignoring treaties and anything else, if you sell this investment that's based in Canada, yes, a capital gain would be subject to tax in Canada. The way it works in Canada is that only half of a capital gain is subject to tax, but it's taxed at whatever your tax rate is based on the value of half that gain, right? So whatever our graduated rates are. And being a US person, yes, you will be taxing the US on that capital gain as well. But in the US, they tax long-term capital gains, meaning the investment's held for more than a year, at either a 15 or 20% flat tax rate. So taking into account foreign exchange rates, how Canada only taxes half of it, the US only taxes the full amount of 15 or 20%. There could be times where the foreign tax credit actually offsets the US tax dollar for dollar, or there could be times where there's some leakage, meaning you paid more Canadian tax that the US gives you credit for, or vice versa. Maybe the Canadian tax rate was lower in this case. Now, I will say under the treaty that Canada has with the US, they do have certain exemptions applicable to capital gains where they basically say they will only be taxable in the country you're a resident in. So depending on the type of investment you have in Canada, you might be in a situation where you don't even have to pay tax to Canada as long as you're not a tax resident of Canada during that time. And ultimately, you really just got to pay tax to the US. So at the end of the day, you're going to pay one tax. It's either it's split through a foreign tax credit, or you're just paying one country because the treaty exempts you from the other one, right? So yeah, so I would definitely keep that in mind, how Canada and US taxes capital gains differently, and they take into account exchange rate differences, and then also whether a treaty exemption may apply. So.
Perfect. And I see a question about healthcare there, which following on Felix's message, I acknowledge it might be a little too specific for the team right now. So yeah, we can follow up on.
We can connect Michael with some of our healthcare specialists at the firm to speak towards that question directly.
Okay, perfect. Is there any other questions? Are there any other questions here? Any last words from Felix, Frank, or Fiona? We're good.
I would just say thanks so much for joining us, and we really look forward to continuing this discussion.
Yeah, I'd like to second that as well. So thank you.
Perfect. And thank you to all the speakers and to the Alliance of Angels and the Canadian Consulate in Seattle for all the joint work to put this webinar together. The idea was to have a really practical session, like a place where we could like discuss openly about the pros and cons of investing in Canada, of investing in British Columbia. And we will be following up with an email with the contact information of all the people, all the speakers and presenters from today's session. And can we share those slides with the audience members, Fiona and Felix? Is that okay?
Yeah, certainly.
Okay, great. So we will be sending that as well. So thank you all very much for joining, and we really hope you enjoy the session, and looking forward to chatting with you all in the future as you expand into Canada.